The torts question from July of 1995 is yet another very instructive question. Take a look at the cause of the question, and you'll see it's a very standard civil remedies call. 1. What claims, if any, does Walker have against Booker? Discuss. 2. What claims, if any, does Walker have against the News? Discuss. Well, up front we know a fair amount about what's going on in this question. We've got one civil plaintiff who is suing two different civil defendants, somebody called Booker and some organization called the News. And we can intuit a fair amount about what's being tested here without even reading the fact pattern. Just about the only time that a media outlet is a defendant in a civil lawsuit is in cases where the plaintiff is alleging defamation or invasion of privacy. And one of the defenses to liability certainly is going to be the First Amendment to the U.S. Constitution. So for both lawsuits, our plaintiff is going to have one or more theories of liability, and he's also going to have one or more prayers for relief. And those are going to include damages, restitution, or equitable relief. So we can organize our thoughts about this fact pattern before we even read it. Our job is going to be to determine what the theory or theories of liability are, break them into elements, and then narrowly and specifically connect facts from the pattern to elements of the analysis. Have a look with me at the top of the question. Let's review the fact pattern together. In paragraph 1, we meet our first defendant, Booker, the owner of the bookstore. Walker, our plaintiff, is a clerical worker in a nearby office who comes into the bookstore every day at lunchtime to browse. In other words, he's not a buyer, he's a reader. Booker became annoyed because Walker read books and magazines but never bought anything. Finally, Booker told Walker that he would call the police if Walker came into the store again. Okay, no torts have been committed so far in this first paragraph, but I think we can see a scenario developing in which torts will occur. In paragraph 2, we see Walker returning the next day, and Booker calls the police. Booker makes a citizen's arrest of Walker for violation of the local vagrancy ordinance that made it a misdemeanor to, quote, loiter in an annoying fashion in any place open to the public, close quote. Walker objected loudly to the arrest, yelling, "You can't arrest me, I didn't take anything." Okay, stop right there. We don't have to be Dean's List scholars on torts to get the idea that false imprisonment may be getting tested here. Now take a look at paragraph 3. Here's how the media outlet gets involved. Reporter overheard Walker's remarks. Reporter worked for the News, the local newspaper, and recognized Walker because 1 year earlier, Walker had led a movement to remove certain books from the local high school library. Okay, we can stop right there and intuit what is going to be at issue. There's going to be some defamatory statement alleged by the plaintiff, and the defense is going to be a fine point on the First Amendment. It will be the public figure or limited purposes public figure line item in the First Amendment that requires malice be shown when a defamation action is brought against a media defendant. Reading on, reporter thought that the police were arresting Walker for shoplifting and rushed back to the paper to file a story on the arrest. Okay, what do we know about the First Amendment in this context? Absent actual malice, there's no liability. So here it looks as if we've got a reporter who is in the process of making an honest mistake. Look at paragraph 4. The next day, the News reported that Walker had been arrested for shoplifting in a story headlined, "Book Burner Arrested for Book Theft," a clear allusion to the earlier public figure status of Walker. In paragraph 5, we see that Walker is charged with vagrancy. The charge was dismissed on the ground that the vagrancy ordinance had long been constructed to require an actual disturbance of the peace, and in this case, there was no actual disturbance. So, here we've got a malicious prosecution theory of liability, and the fact that the defendant, now plaintiff, was exonerated from the charges helps in that civil theory of liability. And that brings us again to the call of the question, Walker versus Booker and Walker versus the News. Now have a look at the outline of issues, and you'll get a very clear idea about how I organize an answer to this question. And once again, you're going to see that I am not doing anything terribly special. I'm following the format that I've suggested we would use upon reading the call of the question. All I've done is spotted the actual issues and split them up accordingly. So take a look at the first lawsuit, Walker versus Booker. The first tort theory of liability is false imprisonment, and you're going to see internally I'm using the facts to organize. Next, we have two different theories of liability, malicious prosecution and intentional infliction of emotional distress. And you don't have to agree with me necessarily that liability will attach. But I do think that these are testable issues, and the idea when we get a call of the question that asks about theories of liability, well, we want to come up with as many as we can. To some extent, our grade is going to be based on quantity, not just quality. Next, we consider Walker's possible lawsuit against Booker for the actions of the News that happened subsequent to those that we are actually suing Booker over. We'll take a look at that when we get to a review of my analysis. Next, we see the second lawsuit, Walker versus the News. And here you'll see I'm not doing anything terribly innovative either. I'm just putting together a couple of the invasion of privacy theories and adding a few internal ideas. So with regard to the first lawsuit, defamation, I've got the idea of libel per se, since the newspaper is alleging an act, or at least an accusation of an act, which is a crime of moral turpitude. I've got a separate paragraph for the public figure analysis, and then we reach a conclusion. False light and IIED are somewhat tertiary theories. Obviously, the core theory here is defamation. But remember, defamation and false light often are tested together. And this fact pattern gives us a good example of how it looks. So that wraps up a consideration of how to organize an answer to this question. Now let's turn together and have a look at the answer that I've presented. You're going to see, as usual, I'm using my outline as the structure of my answer. I'm not changing the outline at all. The purpose of creating the outline was to create a reader-friendly structure that will allow a disinterested grader to skim our answer quickly in a few short minutes and see that we know what we're doing. We want that grader to see that we have spotted the issues and analyzed the important facts. So now let's have a look at my answer to this essay question. You're going to see up front, I lead with the facts. I indicate that Booker threatened Walker with arrest if Walker showed up again without buying anything. Walker returned, Booker had him arrested. So we go to the first, and I think the primary theory of liability, false imprisonment. You'll notice I define it briefly in the heading. We are staying away from elaborate boilerplate definitions. Our job is to show that we can analyze the facts in light of the legal rules. So the rules matter, but we don't get a lot of points for reciting them at length. So internally, I talk about the citizen's arrest that Walker made on Booker for vagrancy. But the vagrancy charges are dismissed, and so the bottom line is Booker is liable to Walker for the theory of liability of false imprisonment. If you look at the internal paragraphs, those three that relate to false imprisonment, I think you'll see a good example of factual analysis. We move on to malicious prosecution. Here, again, I define it very briefly, but I do define it. Then we work in the details about the facts. It seems to me apparent that liability will attach to this theory of liability too. Next, we move to IIED. Here, we focus on the conduct of the defendant, and our primary goal is to make a judgment whether or not that conduct was outrageous. In this case, it seems apparent that it was outrageous, although, I'll grant, reasonable people can differ. Then, finally, I consider Walker's claims against Booker for the actions of the News, and it seems to me that this probably goes a little bit beyond what would be reasonably foreseeable under the circumstances. And I'll also indicate that this section, with regard to the possible liability of Booker for the actions of the news is itself a tertiary theory. If you left it out, there's no bad consequences. But I do think that you'll agree that including it does make the analysis a bit more thorough. Then we move on to our second lawsuit, Walker versus the News. Here, I lead with the facts again. I set up the context for what happened. I explain the situation, and then we move on to defamation. Once again, I define it up front, but very briefly. Then we go into the analysis of libel per se and the fact that our plaintiff, Walker, almost certainly is going to be considered at least a limited purposes public figure. So as far as I'm concerned, the bottom line is that the lawsuit against the News for defamation is going to fail because of the good faith of the reporter and because of the limited purposes public figure status of our plaintiff. Next, we move on to false light. It's a much less serious theory of liability. All of the facts that give rise to it are identical to those that give rise to the defamation action. But, once again, the First Amendment will act as a bar to liability. Finally, I talk about intentional infliction of emotional distress. Here, there's no deliberate intent to harm, therefore, no liability. So that wraps up a consideration of a fairly standard, but not uncomplicated, fact pattern.